and what has to be proved. So countries that have adopted competition laws have created a right to a competitive market-based economy. When that right is diminished by the illegal anti-competitive behavior, the victims are both individuals or businesses, as well as general public. The public interest is represented by the government's competition authority. However, private victims should also have strong expectations, not only that anti-competitive behavior will be stopped by the government, but also that they will have a right to compensation for injury caused by illegal anti-competitive behavior. The question is how these expectations may be best met. Outside the US, antitrust enforcement has been overwhelmingly a matter of government enforcers, with private rights of action either non-existent or not well developed. This is the current situation in Europe as well. We know that the European Commission conducted a study which found that there is a significant underdevelopment in private damages actions in Europe. Therefore, the European Commission started to elevate its efforts in order to encourage private enforcement. So the question we face is, what is the goal of private antitrust enforcement? The question is, for what purpose or purposes do we want private enforcement? Is it that we recognize that the cause of damage, and is it just for the causer of damage to compensate injured persons? Or is it to supplement public enforcement of a competition law to which sufficient resources are perhaps not being allocated? Or is it perhaps for some combination of both compensation and deterrence? A maximal system of private enforcement will permit both private remedies, damages actions, and injunctive relief for antitrust injury caused by any violation, whether or not the government has investigated and found liability. As jurisdictions around the world consider introduction of private rights of action, the US system is considered to be a model, both a model and a cautionary tale. In the US, private treble damages action has been introduced by the Clayton Antitrust Act in 1914. And the US Supreme Court has repeatedly emphasized that individuals are empowered by the treble damages remedy to act as private attorneys general. So besides supplementing the government's limited resources, private actors may bring meritorious claims that the government doesn't know about or is reluctant to bring for other reasons. So Sections 4 and Section 16 of the Clayton Act provide antitrust plaintiffs with private rights of action. Section 4 of the Clayton Act authorizes any person injured by any activity which is forbidden in the antitrust laws to sue for treble damages. Section 16 of the Clayton Act authorizes any person to file for an injunctive relief against threatened loss or damage by a violation of the antitrust laws. The Clayton Act authorizes private actions to enforce the federal antitrust laws, including the Sherman Act, the Clayton Act, and Section 2 of the Robinson-Patman Act. And damages action can be, or injunctive relief, can be filed for any forbidden conduct which includes monopolization, attempted monopolization, per se unlawful concerted conduct, for example, like price fixing or market allocation among competitors, and other agreements that unreasonably restrain trade, and as well as certain types of price discrimination. What makes a US system of private rights unique are following features: availability of opt-out class actions, favorable discovery, trial by jury, joint and several liability, mandatory trebling of damages, one way in favor of plaintiff recovery of attorney's fees, and tolling of the Sherman Act's limitation period during the pendency of government investigations. while private enforcement in the US is well and alive. The features I just mentioned, and you can see on the slide, are widely perceived to promote excessive litigation and litigation abuse. I would like to stress that there are tangible benefits of vigorous private enforcement as an effective complement to public enforcement in the US. Again, here I would like to stress and quote the US Supreme Court from Reiter Santone, where the court, I quote, says, Congress created the treble damages remedy precisely for the purpose of encouraging private challenges to antitrust violations. These private suits provide a significant supplement to the limited resources available to the Department of Justice for enforcing the antitrust laws and deterring violations. And finally, one of the few empirical studies conducted is an empirical study conducted by Robert Landa and Joshua Davis, which documented the benefits of private enforcement by analyzing 40 of the largest recent successful private antitrust cases in the US, resolved since 1990, which, although is not comprehensive, it made several significant findings, and one of them is that 40 cases analyzed provided a cumulative recovery to consumers and businesses of at least between 18 and 20 billion of dollars. So the study tends to support the view that private enforcement in the US is generally doing its job, ferreting out antitrust violations that otherwise would not have been exposed, providing significant deterrence beyond the criminal fines obtained by the government in cartel cases, and compensating some of the victims of antitrust violations. Let me come to European situation. In Europe, we also have private enforcement. As we all know, for damages actions, national courts are competent to decide and file and work on damages claims. And for injunctive reliefs, the competence is being shared between national courts and national competition agencies. With regard to substantive rights for damages claims, all member states, at least in principle, permit private enforcement for alleged breaches of the EU competition rules. However, the substantive basis for bringing such an action varies considerably from member state to member state. Against that background, the Commission followed the reasoning of the European Court of Justice, who emphasized the need for private enforceability of the Articles 101 and 102, and is preparing currently a general and European framework for damages actions to be enacted in the near future. Let me now move from these general policy issues to concrete questions on how damages actions is getting started, when an action can be brought, and what has to be proved. I will compare the US and the elements of the EU civil law system, which I think are most relevant, and any other details we can discuss later on. The question on standing is a very important question. It provides an answer who can file a damages claim. Under Section 4, Clayton Act, a plaintiff must satisfy following conditions. The plaintiff is a person, Section 1, Clayton Act. The defendant acted against antitrust laws. The existence of actual injury being defined as an impact or fact of damage. The antitrust violation was material and substantial cause of the injury rather than incidental or speculative. The plaintiff's business or property were injured, and the injury was an antitrust injury, meaning an injury of the type the antitrust laws were intended to prevent, and that flows from that which makes the defendant are unlawful. Plus an additional criterion, which is called a remoteness criterion, under which the plaintiff has to prove that he is sufficiently close to the defendant's actions. Lower courts in the US confirmed standing for either consumers or competitors and denied standing to creditors, the employees, officers, shareholders, and suppliers of antitrust victims. We all know that direct purchasers do have standing, and the question whether indirect purchasers can file a damages claims was answered negatively by the U.S. Supreme Court in the famous or infamous decision Illinois Brick versus Illinois in 1977, where the Supreme Court held that only direct purchasers from cartel members have standing to bring federal antitrust suits for recovery of their losses under Section 4 of the Clayton Act. However, meanwhile, more than 35 states allow some sort of Illinois Brick repealer statutes that allow indirect purchasers to recover under state law. However, I must say that recoveries for indirect purchasers under these statutes have been limited. Apparently, we will come to this later because of difficulties of proof of harm, as well as the high hurdles that some courts have erected to class certification. Injunctive relief is available to indirect purchaser classes under federal law. This brings me to a question whether indirect purchasers should have standing under EU law, and my answer is yes, they should have standing. The answer on these varied among different member states, and the courts in the European Union have taken different views on this. And we know that in Germany there was a case where the appeal court has found that indirect purchasers would not be entitled to damages. In the policy paper, white paper on damages actions, the European Commission is clear on that issues, and it does say and does confirm that both direct and indirect purchasers should have standing, because everyone who has suffered harm from a competition law infringement should be entitled to damages, wherever on the distribution scale he finds himself. Closely linked to an issue of the indirect purchaser is the issue of pass-on defense, or the question whether or not the infringer should be allowed to raise a pass-on defense if the direct purchaser passes losses on indirect purchasers further down the supply chain. And there, in the Hanover shoe, again, the US court held that the pass-on defense would not be recognized as a defense. In Europe, we don't have a clear answer on that either, because, the views of different courts are vary, and the European Commission took a view in the white paper again, where the Commission is proposing a double presumption for direct purchaser, that a presumption that nothing has been passed on, and for indirect purchasers that everything, all overcharges, losses have been passed on. There is a reverse burden of proof, meaning that the presumption should be rebutted by defendants.